Okay, great. So welcome again. And what we will do here this evening is we'll probably get the presentation started in just a few minutes. And while I guess we're waiting for everyone to still join in, I'll do a little market presentation for everyone, but just to get us started and to introduce ourselves to everyone who hasn't been to one of these events before. My name is Amanda Gates, and my business partner is Greg Ross, and you will be hearing from him in just a moment. And we are residential realtors here in the HRM area, and we are both also real estate investors. So we started doing meetups for other investors in the area. I think it was back in 2019, Greg. We've been doing it for a couple of years now with some hiccups around COVID. We used to be able to meet in person, and now we're meeting via Zoom, but this is definitely, we're still getting out there and still hopefully bringing some information to other investors and still learning ourselves with guest speakers and things like that. So we will be doing an interview here with some special guests in just a few moments. But again, we're waiting for a few people to hop in. I thought I would go over a quick market update just to give everyone an idea of how things are going in the real estate market here in HRM specifically is what I'll be showing you here. So bear with me, I'll just throw this up on the screen and have a little chat about this. So can you see this screen there, Greg?
Yeah, okay. That looks great.
Perfect. So yeah, just something we'll go over quickly here while we're waiting. So these are our stats, and this is kind of a screenshot in time, actually as of November 1st. So when we're looking at November 1st, 2021. If you look over here, you're looking at November 1st, 20. Oh, did my screen go away?
Yeah, sorry about that. I don't know what happened. Go ahead, I'll get it back up.
Oh, there it is.
So it was November 1st of 2020 and then November 1st of 2019, 2018. So it's a really good comparison on how the market looks now versus a few years ago. It's super interesting to take a look at. You will see that right now, well, as of November 1st, there was 330 residential listings in HRM and 801 this time last year. Days on market, it takes on average 25 days to sell a property in HRM. And as you all know, some are selling in just a few days and some are taking a little bit longer, but 25 days is still incredible. Compared to 49 last year. List to sale ratio. So on average, homes are selling for 109% over asking price, or 109% to asking price. But last year it was just around asking price homes were selling for. And then in a typical year, we're looking at about 97% list to sale ratio. So far, it was only the 1st of November, so just a couple of sales. But what's really important to look at here is our year-to-date sales. So we've sold 5,800 homes so far this year versus 5,600 last year. Pretty similar to last year, but a little bit stronger. And months of inventory, homes are taking less than a month to sell versus last year about a month, almost. Oh, sorry. If we were to sell, going a little backwards here. If we were to take all of the homes off or stop listing all of our homes as of today, how long would it take to sell off all of the inventory that's listed right now? And it would take less than a month. So that's, that really comes to show our lack of inventory we have here at HRM. And that ultimately is boosting our overall sale price. So right now, the average home is selling for $475,000 in HRM versus 372 in 2020. And that was a really strong year. You can see how much even that was increased from 2019. And our appreciation from last year is, again, an incredible 21.6% from 2020. So pretty interesting stats. I thought you guys would want to take a look at. And we post these weekly on our Instagram if anyone wants to see these on a regular basis. So what I will do, Lianne, you can go ahead and I'll stop sharing my screen and you can share yours.
Okay.
And yeah, just a little housekeeping note that during the presentation, we will have everyone mute themselves if they can remember to do that. Sometimes background noise can be a little distracting during the presentation, but we will have a question and answer period at the end. So lots of time to ask questions, interact, and go from there. Also, just please keep in mind that any questions and comments are to be kept respectful. Our guests here, you know, there's a lot of some controversial topics going on right now around landlords and things like that. But our guest speakers here, you know, don't have control over that. So let's keep things respectful there. And we really do appreciate their time. So let's show them that.
Okay.
So what I will do at this point is I will hand everything over to Greg here to introduce our guest speakers, and he will, I guess, give us an idea of how the rest of the night will run.
Excellent. Thank you so much, Amanda. It's always crazy to take a look at those stats, especially when you look back to like 4 years ago when we had, you know, over 2,000 properties on the market compared to 300. It like that number just blows my mind, you know, when our market is that small, you know, the amount of listings and the amount of buyers that we have, and we still have more sales than we have over all of those other years. So it's crazy. Thanks for that update. Welcome back, guys. It's nice to be back in front of all of our members, new and old. Our group is growing at an enormous rate, so we're really thrilled about that. The activities that happen on our Facebook page and connecting with people is just awesome to watch. People are getting involved, they're answering questions, they're helping each other, and that's really what we intended for HREI, was to be a place where people could learn, get motivated, and succeed. And you know, I think that's happening now as we sit back and watch this grow. So which brings me to tonight. We're thrilled to have some people from Residential Tenancies take some time to sit with us and answer some questions. So basically, I did up a bunch of questions and we put them together, and I sent them over to Lianne, and she put them in her presentation. So it's not going to be the typical interview process tonight. She's actually built it into her presentation. So that's really awesome. So tonight we have Lianne Chang, and she's the Director of Residential Tenancies for Nova Scotia. She's going to be going through the presentation, and she also has one of her colleagues, Maureen, Acker, and she's a Senior Residential Tenancies Officer. So without further ado, I'm going to pass things over to Lianne. Thanks again. And I'll be kind of in the background, and I might poke my head in and ask you a few questions as we go.
Not a problem. Thanks so much. It's great to be here. First of all, I'll extend my apologies for 2 weeks ago when I was unable to be here. There was a slight injury that we won't speak about right now, but good to know that I'm okay now. So here I am. As Greg said, this is residential tenancies. We don't have a lot to do with real estate sales, but we do deal with landlords who sell their properties, and we do deal with owners who've just purchased. So all in all, we have a small part to play, and this is what we're all about. So what we're hoping to look at tonight is, right. We're looking at leases, service of documents, terminations. We're looking at the sale of the rental property, and if there's any dispute that may come up, and how those disputes are dealt with, and if there are decisions out of that, how they're enforced. Whether you're a landlord that has sold, or whether you're a purchaser that has bought a former residential premises, and that's what we're going to look at. Okay, so in terms of, just get the next one here. In terms of our act, our legislation is there to give landlords and tenants efficient and cost-effective ways to settle a dispute. And it's cost-effective because it costs $31.15. The scope of the act, it applies where there is in fact a landlord-tenant relationship, and where the tenant is living in a rental premises or an apartment, a house, a manufactured home. And it applies to all levels of housing, the for-profit landlords, the public housing, and the cooperative housing. So there are exceptions to that. So perhaps I'll talk about the exceptions. The exceptions are, of course, maternity homes, universities, colleges, institutions of learning, hospitals, that kind of things, homes for special care. And there are some homes for special care that have attached apartment units. And so the home itself may not fall within our parameters, but the attached units that are residential premises would fall to us if there is a conflict with anything. Okay, so as with everything else, between landlords and tenants, they're usually leases. They can be signed or they can be unsigned. There are parties who are unaware that you can have an unsigned lease. You agree to the terms and conditions of the lease, and then you don't get into the lease, and you have an unsigned lease. An unsigned lease is a statutory lease. It can be year to year or month to month, and all the terms and conditions that apply within the Residential Tenancy Act applies to an unsigned lease. All leases must comply with the Act. You can't contract out of a statutory clause under the Residential Tenancies Act. Landlords set their own rules, and those rules must be applicable to everyone. Every tenant must receive a copy of that rule, and they must be reasonable. Of course, reasonable can be interpreted in different ways. So if there's a question as to what is reasonable within a lease, it falls to a residential tenancy officer if either the landlord or the tenant has issues with reasonableness. It's got to be applicable to all the tenants. So you can't have rules for tenants on the first floor, but the same rules don't apply to the tenants on the second floor, and the tenants on the third floor have a different set of rules. It's one rule for everyone, and it's for every single tenant. The rules should protect the comfort and safety of the tenants or protect the landlord's property, right? The rules can be changed. Yes, rules can be changed, but when you change it, you don't change it for a tenant, you change it for all the tenants. And the time period in between rules being changed is usually a 4-month notice before each tenant's anniversary date. So that can be a problem where every tenant has a different anniversary date, but generally speaking, once it's the same set of rules that go out to each tenant before their specific anniversary date, there should not be a problem with that. Again, rules can't contravene the legislation or the standard form of the lease. Sometimes you see parties putting in place a lease and they cherry pick the terms that they wish to apply to them or to their tenants. A lot of tenants don't challenge it, but they can if they wish, and then it's up to the program to determine whether what has happened is a contravention of the Act or not. So one of the questions that Greg had posed is, can you change the terms of a lease after it's in place? Items such as changing landscaping, plowing, heating, or any of those kinds of things that are incorporated into the lease and make it the responsibility of the tenant. So one of the things the legislation speaks to is that if there is a utility or a benefit to a tenant, and the landlord removes that benefit, it's seen as an increase in rent. So if, for example, you have a tenancy where you are allowing the tenant to have, including in that, power, and you want to change that term of the lease, prior to November the 26th last year, you could do that comfortably, and I use the word comfortably. Since then, of course, there has been the 2% rent cap. And what that means is that any increase in rent cannot be more than 2%. So on $1,000 rent, the increase is $20. But incorporated into that $20 is the power bill. So if you're going to take away the power from the tenancy, whatever you take away together with any increase in dollars in that lease must be equal to or less than the 2% for the rent cap. And that's kind of tough. So the answer is yes, you can change the terms of the lease after it's in place, but you have to do so with notice to your tenants. And if you remove any of those utilities, it is seen as an increase in rent.
So Lianne, I guess if somebody wanted to change the terms such as power, having power not included in the rent, they would have to reduce the rent basically.
Right. So let's say the power bill was $75 a month. You would have to reduce that $1,000 rent to $925 and then add 2% onto it.
Right.
Yeah, that's essentially how it would work. So rental increase can only be once in a 12-month period, and there must be 4 months notice prior to the anniversary date of the lease. That's for a year-to-year or a month-to-month lease. For a week-to-week lease, and we do have week-to-week leases at times, there must be 8 weeks notice prior to the anniversary date. And then of course, there's the fixed term lease. So the fixed term lease, it starts on one day and it ends on a particular date. So you can have a fixed term lease from the 1st of January to the 31st of December. So you know your start date and you know your finish date. And the rent there is fixed for the term. Now, if that lease rolls over and it rolls over with the same tenants and the same premises, you can raise the rent from the 1st of January, but you would have had to have given notice 4 months prior to that 1st of January anniversary date. So it's applicable to all types of leases. One of the other questions you asked, Greg, is what's the distinction between guests living and visiting a property, for instance, if they're not on the lease? So leases usually have all the terms and conditions in it, but it also has occupants. So you may have a tenant, and that tenant may be one person or two people, and you may have other persons who can live on the property. Guests can come and go. That would be a discretionary situation, and you'd rely on the language in the lease in terms of guests coming to stay there. But you know, it always happens that you have guests who kind of overstay their welcome sometimes, or in some cases, the lease is for one person and a friend comes to stay, and they're there and they're couch surfing. And a lot of landlords think, oh, you're not on the lease. You can come and visit overnight or maybe for weekends. But when you start overstaying your welcome, and you know, this is like week 7 that you're still here, that can be, the landlord can see that as a breach of the lease. You have someone else occupying the premises with you who's not allowed to be there, whose name is not on the lease, either as a tenant or as an occupant. So those are the other little things that we look at. All right. So let's go to the next one. If there's any questions, please, you know, feel free to
Yeah, we'll open it up to the group for questions near the
okay.
end. Just as we go, I might ask a few. So when somebody ends a fixed term lease and they decide they want to stay and you're in agreement, at that point, can the landlord decide to change the rent more than the 2% cap, or do they have to observe the 2% even though that fixed term lease is over?
You're rolling over the fixed term. It's the same tenants and it's the same residential unit. So it remains in place. The 2% cap applies. It wouldn't apply if it's a new, if it's a new premises or they're new tenants, right? Yeah. Either of those two. So it is attached to the same tenants and the same unit.
And okay, perfect. And one other question from your last slide, an unsigned lease. In what circumstance? Can you give an example of where an unsigned lease would be in place, or that would happen?
An unsigned lease is a pretty simple thing. Someone wants to rent and they move in, they pay their rent, they pay their half month's deposit, but you don't ever put in place a written lease. So it's an unsigned lease. So once they move in and you create that landlord-tenant relationship, they're in your premises, they're paying their rent, they have handed over their half month's statutory deposit, and they become a tenant. So there's no lease written in place. It's more common than not that there are unwritten leases.
Okay.
But it's still a lease because you have to abide by the terms of the legislation. So the rights and responsibilities are still there, and both parties have to abide by it.
Perfect.
Okay, so we can move on to slide 5. So terminating a tenancy. Okay, so once someone moves in, they have what we refer to in the landlord and tenant world as immediate tenure. I know that there was a time when if you had a tenant, a landlord could say 3 or 4 years down the road, I think I want a new tenant, and they can give you a notice to quit, and they did not have to have a reason. Landlords are no longer able to do that. So you must, and it's applicable to any type of lease, the year-to-year, month-to-month, week-to-week lease, so that if the landlord wants to give you notice to quit, they have to have what we refer to as cause to do that. Whether that cause is non-payment of rent, whether it's breach of the lease itself, whether it's breach of the statutory terms of the lease, there must be a cause for it. Now, fixed terms are not actually subject to immediate tenure because there is a fixed term. It starts on the 1st of January and it ends on the 31st of December. So it's a fixed term. Of course, if you don't pay your rent, your tenancy is always in jeopardy, whether it's a yearly, a monthly, a weekly, or a fixed term lease. It's the payment of rent, for me, is the cornerstone of the contract between the parties. I pay my rent, I get a place to live. So if and in terms of terminating, if a tenant doesn't comply with an eviction notice that a landlord gives them, the landlord, the legislation, that is the Residential Tenancies Act, does not support a landlord personally evicting a tenant, i.e. showing up on the doorstep and saying, the notice expires tomorrow, you need to leave. So if they don't leave, what a landlord has to do is they must apply to the program for an eviction order based on the notice to quit and or any other reasons that may apply to that situation. So one of the other questions that Greg sent along is, if an investor is purchasing a property, I don't know if it's the right time to talk about this. If an investor is purchasing a property such as a duplex and wants to move into to one side, what's a protocol for letting the tenant know and how much time has to be given? So I'll say that to terminate the tenancy, all tenants have to be provided with a notice to quit under the Act if the landlord wants vacant possession for any reason whatsoever. And owner occupation is one of those reasons. In this case, a landlord must let the original landlord must tell the tenant that they're selling the property or they have sold the property, and provide the tenant with what is called a director's form. We refer to it as a DR2, and that's what we know it as. It's a director's form that the property has been sold to someone who intends to move in, right? So the legislation says you must give the tenant notice to quit when you sell the property that has 4 units or less, and the new owner or family member is going to move into the premises or occupy it for themselves. Family member is quite specific. So, if a new owner is moving in, that's great. They're the new owner. But if they want a member of the family to move in, they need to check and make sure that the legislation is being complied with. The effective date of the notice that the landlord gives the tenant must be no earlier than 2 months after the date that the tenant receives the notice. So you get the notice on January the 1st. It can't be earlier. The eviction date given on the notice can be no less than 2 months later. So you need to give that notice on the 1st of January for March the 1st or beyond. If it's a fixed term lease, the effective date must be no earlier than the date specified at the end of the tenancy. So again, fixed terms starts on the 1st of January, ends on the 31st of December, and the notice you give will be for the 31st of December. Okay. Again, if in any of those situations, the tenant does not move, you must go to the program to ask for an eviction order. And under the current legislation, the RTO can give anywhere between 2 to 12 months to vacate the premises. That sounds like a long time, and it is, it's 12 months, but that's where your advocacy comes in, that you can, in the hearing, put forward all of those reasons that you think that it should be sooner rather than later. There was a follow-up question that was sent. What if the person who purchases wants to moves into the first side? So the process is followed. The current landlord sends the notice to the tenant. The 2 months are given. Let's for argument's sake say the tenant moves. So you get to purchase the property and you move into that side and everything goes great. But then, as Greg says, 6 months later, after living on one side, they decide they want to move into the other side. Now, Greg, that's a tricky question. And I'm sure you can see where I'm going with that. That is something that only a residential tenancy officer would be able to determine. I don't know from where I sit, if someone purchases and they purchase one side and then they tell me, you know, I really didn't like the left side of the building. I want to move into the right side. Honestly, it sounds like I'm trying to be, you know, put it in the right way. They seem to be attempting to get possession of both sides of the premises of the duplex. So the question would be, the next question you have is, how long does this process typically take from beginning to end? So if you give them on the 1st of January to vacate on the 1st of March, that's 2 months. And it's only after that period has ended that you will go to the tenancy program. Many persons come before, but the question is always, can I ask for a termination order before that time? And many people do that. But again, you have, hello?
Oh, it's just somebody didn't.
Oh, okay. Yeah, you can go before the end of the period, but any order that is made would not be made as of today. It would be made in accordance with the current legislation of between 2 and 12 months. So the tenant gets a notice to quit, and you know, that's the process you follow. So if you went into the program today, in the normal course of things, you could get between a 4 and a 6 week hearing date. There are times when it's a little longer. There are times when it's a little bit less time. So it gives you enough time to get your evidence in, and basically, as I would say, your house in order. There were a couple of other things that I thought I could talk about in terms of terminating the tenancy. In terms of if you have a landlord whose tenant is not paying their rent, the tenant has to be given a notice to quit in the form saying you haven't paid your rent and you have 15 days to pay. You're 15 days in arrears, and somehow that 15 days ends up being 17, because when you count days, the day actually ends at midnight. So you have to really start counting time from the next day. And even those 15 days, the 15th day ends at midnight. So you're looking at 17 days really. And so the counting of these is pretty important. So I have to emphasize that if a tenant does not leave, the landlord must get an eviction order from the director based on any of the reasons that might have been given in a notice to quit. All right.
And just I'll jump in here for a second, Lianne, too, is because there's also the process whereby upon being notified of a notice to quit by a landlord, the tenant also has the ability to approach the residential tenancy program and file an application to have it set aside. So in other words, to ask the residential tenancy officer to get involved to say that the reasons for the for being given that that notice to quit to start with may be faulty, and have a hearing about that. So there's that then termination of tenancy may come about as a result of that as well. So the tenant also has the ability to approach the residential tenancy program once given a notice to quit. Just wanted to clarify that.
Right. Thanks, Maureen. So that process gets sort of segued into a hearing at that point. So one of the very interesting things that I'll throw in here is that in the normal course of things, if a tenant applies to have a notice to quit set aside, usually a landlord can counter complain that I'm going to contest this, but I want an order saying that this tenant should be evicted. So currently, if you don't do that, and the order to set aside the notice to quit is not upheld, i.e. the application is dismissed, nothing happens. The landlord does not get an order for eviction. I'm sure many of you may have seen Bill 30, which has a couple of amendments in it. And one of the amendments relates to this, and it's this. If a landlord serves a notice to quit and a tenant contests it, and a landlord does not file that counter complaint asking for an order for eviction, if when the hearing is dealt with, the tenant is unsuccessful and the notice to quit is upheld and it's not dismissed, the legislation now plans to give the residential tenancy officer the authority to make an eviction order at that point against the tenant once the notice to quit the time has passed. So that's a very interesting amendment that's going to be going through. It's one that landlords have been speaking about for quite a long time, but it's one that has only now come on to the books. So I don't know if there's any questions on that. The act is, I think it had the third reading today. So I don't know what will happen, in the next couple of weeks. I think the House is closing next week. So we'll soon find out what's going to happen with that.
I'll just jump in here too, Lianne, and say that from an officer hearing such a case, it's going to make things much more clear.
Yes.
In terms of what the outcome is. So it's an improvement from the point of view of the officer who's seized with looking at all aspects of the situation, that they can then, find that in fact, there was not only just grounds for the notice to quit for being given and to start with, but also that they will endorse the eviction as well. So that's an improvement from the officer's point of view.
Right.
And would that happen during a hearing?
That
Yes.
all the evidence would be gathered during the hearing,
Right.
and then the director's
Right.
order would be issued pursuant to that. That's correct.
Okay, that's great.
Yeah. So if it is that a landlord gets their eviction order, that order stands and a tenant is given X amount of time to leave. Like with all court processes, the losing party has the right to appeal. And if you've ever seen a director's order for residential tenancies, the right to appeal is within 10 days after the date of the issuance of the order. That's and it's 10 calendar days, so it's not 2 weeks, so it's just 10 days. Once that happens, there's a whole small claims court process that takes on a life of its own after that. And it may be a further 4, 6, 8 weeks, I'm not sure. Sometimes what happens is that the losing party may not immediately file an appeal. They may take a while, and there's always the possibility that they are allowed to file a late appeal. So they may file an appeal as late as 3 weeks away. So that just adds a little bit more time onto it. And I'm thinking of it from the point of view of a landlord getting possession and wanting to move in. So those are timelines that, you know, they have to be aware of. And even when the small claims court adjudicator hears an appeal, they have quite a few days. Like we have 14 days to make our orders, but I think they have 6 weeks, if I'm not mistaken, to have an order. And then it goes to the sheriff's department, and that could be another 2 or 3 weeks. So all in all, it could be 6 to 8, maybe even more weeks, where if you from beginning to end of a process. So it can be lengthy at time. So that's terminating the lease. So one of the other things is that once you file an application, so you give your tenant a notice to quit and he doesn't leave, you file an application saying that I want to get my property because it's being sold. You have to serve that application on the tenant because they have to know what they have to answer to. And there are a couple of types of service. So there's personal service, there's prepaid registered mail, and there's electronic service. So a lot of landlords have put electronic addresses into their leases. It makes life so much less complicated when you can email anything, the notice to quit and the application for termination, to a landlord or to a tenant. So that's something that came about in 2017, and that's a pretty good amendment.
I was going to say this is probably the biggest takeaway, I would say, from a point of view of anybody who's doing entering into leases with people, is getting this 7 and 7A section of your lease so that you can do electronic service. It's extremely valuable for both sides.
Right. Yeah. A lot of landlords don't actually use it. I think a lot of people have copies of leases. They photocopied many of them years ago. They have the old lease and they don't put that section. They don't use the new lease with the section in, but it's always a good thing to, when you have landlords who are clients, make sure they use the newest version of our lease that is always on our website. And once Bill 30 is brought into law, we'll be amending it again because Bill 30 speaks to texting documents and texting notices. We've got to come into the 22nd century. Most of us have our cell phones right by us day and night. So there are going to be new provisions added, just as we added the provisions for service of documents via mail and via electronic mail. We are going to be adding texting in the next iteration of our lease. So let's, I'm probably talking too slowly here. We started at 7, it's 7:45, so I need to get a move on.
Take your time.
Other types
this is great.
other types of service of documents that are applicable to applications, sometimes we leave notices in the mailbox or in the mail slot. We leave notices, like if you're going to give a 24-hour notice that you're coming in, we leave it with by personal service on an adult who lives with a tenant, not just an adult who's visiting, but we sort of have to ask, do you live here? And there is that. Or sometimes we leave it in the tenant's mailbox, where the residential premises are, if they still reside there. So then we come to the sale of the rental property. So where our residential premises are sold, the existing tenancies are transferred to the new owner. They become a new landlord. All the security deposits go with them. All the security deposits are deemed to be transferred to the new owner, and all of the responsibilities that go with the premises are now transferred to the new owner. The existing tenancy can't be terminated unless the new owner wishes to reside or a member of their immediate family wishes to do so. And there is in fact a process which we alluded to earlier that must be put into place before the new owner can move in. And this will be done by serving an eviction notice using this director's form that is there. So this too has kind of changed a little bit. And I think the next slide I have may deal with it. Let's see. So currently, if there are 4 units or less, and the landlord has entered into a purchase and sale agreement, excuse me, in good faith to sell the property, and all the conditions of the sale have been satisfied, and the purchaser asks the landlord in writing, and these are documents that must be produced in the application if it goes to that stage to get possession of the property. The purchaser has to go on affidavit and state that they intend in good faith to occupy the premises themselves. So this too will change under our new legislation. And what it is that if you have 4 or less units and
I think Lianne might have frozen up there.
Yeah, I think so. I was wondering if it was my internet connection.
Maureen, are you still there? Did you want to pop in? Maureen. Yeah, you're still muted, Maureen. I'll just give him a sec here to come back in. Oh, we lost him altogether.
We've actually done this quite a few times for our clients.
What's that?
Was provide affidavits if they choose to live in the property, which I wasn't aware needed to be 4 units or less. I've never had a client ask to do it in a larger building, but always learning something.
Yeah, we did have that the one tenant, the one purchaser that bought the 4 unit, and she moved into one of the units. So
yeah,
I guess it's all right within that those requisites. So I think that what she was alluding to there was you know, the affidavit not being required if you have the DR2 form. Maybe you can comment on that, Jenna.
Oh, she said there was it. She did mention that you need an affidavit.
Yep.
But I guess you probably need both forms, the affidavit with the other form.
Did we lose Lianne?
Yeah, we lost
Yeah.
Lianne.
I was out too, and I'm back.
Oh, yeah, awesome.
Yeah, I just all of a sudden went away. I'm not sure what happened, but anyways, I'm back. Not sure where you were with your with the conversation. It sounds like you were talking still about the process when there's a 4 or fewer.
Yeah, we were talking about less than 4 and the DR2 form and the affidavit, I guess, is where she was kind of going. So correct, maybe you can allude, just expand on that a little bit with regards to, the DR2 form and the affidavit? Like, are they both necessary in the new legislation, or is one crossing out the other?
Yeah, to be honest, I'm not as up on what the new bill says. I'm more, and we're dealing with the old process until that goes through. So I mean, that's proposed legislation, right? So it's in the House as we speak. But so in the way that we're going to be dealing with it until such time as it changes, then yes, the affidavit. It's one of those processes that if it's done correctly, we rarely would see it in a hearing. Essentially, the 90% of the time, a tenant is aware that if the residential premises is sold and they're served with these documents, that they know they have to be out within 60 days, and very few of them really have a problem with it. And if they come to us and all the I's are dotted and all the T's are crossed on the side of the purchaser and the landlord, then they don't have any recourse.
Right.
It's actually one of the more smooth processes when applied correctly. But of course, what comes to us a lot of times is when it's not done quite right. And unfortunately, if it comes to us, then it's we have to apply the act. And if it's not been done properly, then we're not going to be able to find in favor of the person who's sort of, I guess, on the end of the stick that made the error, for lack of a better way of putting it. Yeah.
Right.
And we actually have a kind of a follow-up question to this. Someone's asking, when providing this form for a 4-unit or less, can you do this if the purchaser says they're occupying the whole building? Now, I believe if you say you're purchasing a 2-unit and the purchaser wants to live upstairs, and then maybe or in one of the units, and maybe they have like a direct family member, a mother-in-law or something that wants to live in the other unit. Does that fall under the family piece to evict more than one of the tenants?
Yeah, so the family member is defined in the act. I'd have to have a look and see exactly what the interpretation is of family member. So family member means the individual spouse, a child of the individual or the individual spouse, a parent or legal guardian of the individual or the individual spouse. So we would have to look at who that person allegedly was and what their role was in the family before we'd be able to tell you for certain whether or not that would fall under the same guidelines.
And they just followed up with sister. Does that?
I'd have to read it again. 1 second. Family member, the individual spouse, a child of the individual or the individual spouse, a parent or legal guardian. So yeah, no, not a sister.
Okay. Perfect. I think Leanne's trying to join back in, but I have quite a few, just a couple of follow-up questions to some of the conversations we've already had that maybe we can have a chat around while we're waiting for Leanne to jump back in. Yeah, so when we were, now I'm going back.
There's Leanne back.
Oh, we got Leanne back. She's just connecting to audio now. So maybe we'll just hold off the rest of the questions till.
Oh my gosh. I
got kicked out too, Leanne.
Oh my goodness.
I don't know what happened. Me too. So anyway, we were just talking a little bit more about the DR2 process while we're waiting for you.
Sorry about that. I don't know what happened. Okay, so let's try this again. Host disabled participant screen sharing. Okay.
Maybe I have to make you a co-host again. Here you go. Now you should have the ability. No worries at all. I don't think we've had a Zoom call where we haven't had some technical difficulties.
Oh yeah, and that's of course the only time it seems to do that, when you have a big meeting.
Yeah.
Oh my word. Okay, just let me know when I can do that again.
You should be a co-host now.
Okay, share screen. Okay, here we go. Let's see if oh, wow. Okay.
There we go.
Are you guys seeing me again?
Yeah, we see you. Your screen is just loading onto. There you go.
Okay, I think I'm sharing the wrong screen there. Let me get the right screen here. The correct screen.
See your presentation, the sale of rental property.
Right, sale of rental property. Okay.
Yep.
Yeah. All right. It should.
It's just a little smaller than it was before.
It should have been the other screen. It wouldn't let me share that one. I'm not sure why. That's okay. Never mind. So we were chatting about the sale of the rental property and the DR2. So you guys was chatting with Maureen about it. Landlord provides a copy of the affidavit. We briefly spoke about it. The date must not be earlier than 2 months away. And for fixed terms, it has to be the date specified on the lease agreement, right? Is this the same slide here? Just bear with me a minute. I think I've got my slides mixed up. Right. Okay, so then we go to the next one. So once you give your tenant a notice, once they receive that eviction notice, the tenant can end the tenancy at any time before the date specified in the notice, but must be at least 10 days after they get the notice. Okay, so you can't give them, if you give them the notice on the January the 1st, they can't come to you and say on the 2nd, okay, I'm gone. They in turn must give you that period of time before they are able to move. Okay, so and then of course there's the renovations or renovations as we call it. Come on, right? So I'm trying to get my screen a little bigger. I don't know if I can get that a bit bigger so everyone can see a bit more. No, it's not happening.
If you hit slideshow there, we don't see your mouse moving around. Maybe if you like where it says slideshow.
No, I'm not doing it as a slideshow. So the next thing is the renovations. As you would all recall, last year our minister made an order that the RTA had allowed that where landlords required the premises for possession, for demolition rather, or making repairs to the extent that the tenant had to vacate the premises, an order could be obtained for an eviction in those circumstances. You may all recall that at that time there were several eviction orders made, and many of them went into the news. So what has subsequently happened is, if you see Bill 30, there will be new guidelines where new sections are added. It says a residential complex is a building where there are one or more premises, right? And a tenant whose tenancy is terminated by mutual agreement is entitled to compensation 3 months if you're in a complex that contains more than 4 residential premises, or 1 month if you're in a complex that contains 4 or fewer residential premises. So it sets out those guidelines where landlords will no longer be, or persons who wish to renovate will no longer be stymied by not being able to do so. Instead, what the Act has done is it's setting out those guidelines where tenants will now receive some form of compensation. If a landlord does not comply with that, the tenant can always go to the program, and the director can make an order requiring the landlord to pay the tenant exactly what the legislation calls for, depending on the type of building that they lived in, or, and it may include one or more of the following: moving expenses up to a maximum as might be reasonably prescribed in the regulations. And of course, the regulations will put minimums and maximums on, I anticipate, any additional expenses incurred by the tenant, and all or any portion of the amount of the increased rent that the tenant now has to pay for up to 12 months. So that pretty much says everything right there. Excuse me. So those are the new regulations that will come into effect around renovations. One of the things that the landlord and tenancy, the parties do is we are complaint driven. Excuse me. So we are complaint driven in that, hang on. If it is that there are problems with landlords and tenants, we only have jurisdiction if someone comes to us and files a complaint. Our decisions are not public. We use a couple of approaches. We use mediation, and if that's where the parties can agree to something, or if that doesn't happen, we go to the hearing stage and we use adjudication to try and determine it. One of the things is that information, we have a lot of information on our website. We have a call center, and a lot of times we encourage parties to try to access our information and communicate with each other. And we have found that in many instances where the parties do communicate, there is a mediation or an agreement that is put in writing for the parties to follow. So the dispute resolution process is, there's a hearing scheduled, you can do the mediation, and that can be done at the hearing or anytime before. The agreement, of course, must not be contrary to the act. And if the mediation is successful, the parties, you can't appeal it, you have to abide by it. And if you don't abide by it, an order can be made using the same terms of the mediated agreement to put into a director's order. The adjudicator and the mediator is the same tenancy officer, and the whole hearing process goes into effect that we discussed a little bit earlier on. There's evidence and there is a decision rendered within 14 days. The process can take 4 to 8 weeks based on the timelines and the ability to appeal any order that is made. Again, the appeal period is 10 days after the decision is issued. It goes to the small claim court in the jurisdiction where the residential properties are located. And if the person who is unsuccessful at the small claims court wishes to appeal that further, they can go to the Supreme Court. If the decision is not appealed, it's converted to an order of the small claims court, and only a sheriff can enforce it. That is, the sheriff can evict a party. And if the excuse me, if that party has monies outstanding, the sheriff, once you present the information to the sheriff where they can garnish the funds, they will do so. And the last thing would be that a lot of information is available on our website, which is here, or there's a contact center, which is a 5200 number. We get about 25 to 3,000 inquiries every year around residential tenancies, but we only have about 5,000 applications filed. It used to be that there were more landlords than tenants calling in. Now we have the reverse, which is more tenants than landlords calling in to get information. That 5,000 applications a year fell last year to a lot less than that because of COVID, but it's slowly building back up. I think one of the things is that a lot of tenants, because of COVID, are not utilizing our service as much as they would have in the past. So that's it. Made it just over 1 hour there. If you have any questions, Greg, or anybody else, I'll do my best to be able, Maureen and I will do our best to be able to answer any of them that might come.
That's great. Well, thank you very much. That was awesome presentation. I do have one quick question before we move past the evicting a tenant in order to renovate a property. You'd mentioned in the new bill that it would be equal to one month's rent. And if that's not given, then it can go through a process where the landlord would have to pay moving expenses. Is there a maximum on that amount? Is it equal to that 1 month's rent, or can it exceed that number if
Well, I
they
think that
fail to follow those rules,
I
or
think
if
the
they just don't know about them, right?
or right. Well, one thing's for sure, our website is going to be updated. The legislation hasn't passed fully through the House as yet, but once it does, there will be regulations in place giving that the kind of maximum amount that can be ordered. Okay. So once that happens, I guess I don't know what it will look like. We're now in the process of getting those regulations prepared. And as you can imagine, there's a lot of consultation that goes into it. So I guess the short answer to that is there could well be a maximum, but I don't know what it will be.
Okay, great. I just have to say too, I went through the process of a couple of hearings in the past year, and it went really well. It was mediated properly. Both sides were listened to, and the outcome was agreeable to both sides. So I would encourage, if there's no resolution happening and it's going in the wrong direction really fast, reach out for some help, because you guys, you understand it and you're able to explain it, and having an independent person speak to the same things that you may or may not understand always helps. So
Yeah.
you guys are doing a great job. Thank you.
Well, I'm happy it went great.
Yep. Amanda, did you have any questions that came in?
I do, yeah. So a few came in a while back about some of the things we spoke about here. So I'm just backing up a little bit. So, okay, when we were talking about the rent cap, there was a couple of questions that came in. One was said, they were asking if you have a tenant, say they're on a fixed term lease, and they agree to a rent increase of more than the 2%, are you able to sign them on a lease for that? Or do you need to essentially evict them to increase your rent?
Okay. The 2% cap currently comes under the authority of the EMA, right? That has come up time and time again. And what I would say is that it's the law in Nova Scotia that you cannot go beyond the 2% cap. And so a landlord would have to abide by it. Right now, and as we said a little bit earlier, you have what is called, I'll go back to that slide. Once you start a lease, you have what is called immediate tenure. So in order for a landlord to have, there must be grounds to evict a tenant. Whether it's a year-to-year, month-to-month, week-to-week tenant, you must have grounds to evict that tenant. And wanting to impose a higher rent than 2% would not be one of those grounds that falls under either the RTA or the EMA.
But if this is a fixed term lease?
If it's a fixed term lease, that's different. But once you sign the same tenants into the same unit, the rent cap holds.
So if they agree to pay more, we still can't?
That's correct.
Okay. And another question was, is there any obligation to a landlord to renew a fixed term lease?
There's no obligation.
No obligation. And if you're on a fixed term lease, do you need to give any sort of notice, or does it automatically end at the date stated? Do you need to give 4 months notice?
You don't need to give
that the lease
notice.
will be ending.
You don't need to give notice. It has a start and an end date. What the best thing to always do, of course, is to remind your tenant that your lease expires on the 31st of December and we are not renewing that lease.
Okay, perfect. So there's a question a while back that says, how does an Airbnb factor into the Residential Tenancies Act? In the case where an Airbnb guest refuses to leave, is the Residential Tenancy Board doesn't get involved at all? It's not their jurisdiction, or is there anything they can do to help someone who is renting their property via Airbnb?
Airbnbs don't fall under our jurisdiction. There's a whole other piece of legislation that covers that.
Okay. And the next question. Okay, so the building and surrounding premises were made smoke-free and pet-free, in part due to health and environmental reasons. Well, it's already occupied. The tenants refuse to remove their pets and or refuse to quit smoking. Is there, because they're grandfathered in, they already live there? Is there a process where you can change the rules? The current rules on the building, maybe after you take ownership, or maybe you've owned the property for a while and now decided it should be a smoke-free or pet-free building.
So as we talked about it earlier, you can change the rules, but the tenants must be given 4 months notice prior to the anniversary date. And the same rules that you give to one tenant, you have to give across the board to all of the tenants. The legislation says that it must be reasonable and applicable to all tenants in the building. So that if you wanted to make it, for example, a couple of years ago when our federal government legalized cannabis, there were a lot of landlords who wanted to have cannabis-free buildings. They wanted smoke-free buildings, which would include not just cigarettes, but cannabis as well. And they had to bring in their rules, had to apply to everyone, and it had to be across the board, and it had to be given 4 months in advance of the anniversary date of the tenants. Now, if every different tenant has a different anniversary date, you'll appreciate that it means that at different times of the year, you're going to be giving out notices. But at some point, you would have covered every tenant in your building. But that's just how the legislation words the requirement to give a notice.
Okay, perfect. Just trying to go through some of the questions here. Jenna, did you type your question in, or I saw your hand was up at one point?
Yeah, so I just wanted to thank Lianne and Maureen for coming. I've dealt with both of you in the past. I'm a property manager, and so I do want to thank you both and say to echo what Greg said. It's difficult sometimes, and sometimes the cases are very emotional, and sometimes it's on the end of the landlord or the property manager that's the agent, and sometimes it's the tenants. So you guys do a very good job of mediating, and I feel like while it's frustrating, when I sit back and I look at everything, the cases are usually, I feel like they're the right decision. When you take the emotions out, it's usually the right decision. So I think
Thank you for that, because we don't hear that. We don't hear the
we don't hear that often enough.
We don't hear the thank yous. We hear the hear the other end of things when people aren't happy. So thank you for that.
Like I feel like I do see, there's some justice there. in the odd case where there's money lost, and it's a tenant that, you know, owes a landlord rent, it's a little frustrating because I feel like it's, you know, something that needs to change would be when a tenant moves on and moves out and is owing rent or maybe had damages, is that you, if you don't have their address and you don't have a way to get it, you're really, it's hard to chase down the money. I basically
Circles back to that 7A section of your act there, of your lease that I was talking about for that very reason. That's one of the biggies for sure.
The email address, that's
Yeah,
right.
getting those email addresses in on your
email
lease are
address. What I'm
helpful.
talking about is when an order goes, there's the order of the director letter, and if it says, you know, Johnny owes $3,000, for example, that's great, you know, you would think that's great, I won, but it's really, really, really challenging to get the money
The
from.
enforcement part of things, the enforcement end.
The
Yeah.
enforcement.
Yeah, the enforcement.
I recently had a tenant, actually it was a landlord who spoke with me, and she had an award against her, and she said to me, the tenant showed, she got a copy of the order, and the sheriff showed up, and what she learned was that the tenant followed her to the bank and so saw where her bank was, and the next thing she knew was that the money had been garnished. So sometimes it takes, I mean, sometimes it's unfortunate, but it takes a little detective work to find, you know, in this case, it might be tenants where they are, where they live, you know. We've had tenants we've had landlords spot tenants in Tim Hortons drive-through, literally jumped into their cars and followed them home. And he knows they're home because they pull the keys out and they open the door, you know. So yeah, it takes some creativity sometimes to locate folks who move out in the middle of the night. Yeah, I appreciate that. Maureen and I do, because we both sat as tenancy officers.
One
Stuff.
thing that I wanted to bring up is this fall, for some reason, I had to file multiple multiple forms, Form J's for hearings. And what kind of struck me was that depending on what the situation is, if you know, if you need to evict somebody quickly, and things are going very bad, you're looking at about 6 weeks to get your hearing, which is very challenging. Is
Yeah.
that it seems like it's delayed further this fall. Is there an issue with staffing, or is it the number of requests that you guys are receiving?
That's a tough question, Jenna, because there are human resources challenges. Let me put it that way. And it's not something that we have any control over. So we are trying our best to reduce those challenges in the hope that once that is done, that timeline will get shorter. I don't know if you had any applications earlier in the year. Our timelines were actually 4 weeks. But as human resources challenges come up, because, you know, sometimes the only solution to getting stuff done is to have more bodies in the seats, as we say. So that's definitely a big part of why those timelines have gone up. We are working on it actively as we speak. Maureen and I are engaged in trying to correct that, but and we hope to get it done very soon and begin to reverse those timelines.
Awesome. Thanks.
So I have one more question here. So what are the regulations for adding an extra tenant to an existing lease, given that both parties agree to a rent increase? Increasing the rent with adding an extra person.
So would this be like during the course? So if you have a year-to-year lease, would this be during the course of the year? Would it be like?
It doesn't say, but I'm
doesn't say.
thinking, yeah,
Okay.
like maybe during the course of the lease, adding in
Okay.
extra.
Another tenant to the lease. So again, that's something that a tenant or a landlord can negotiate with a tenant. It may be that currently it creates a whole new lease, and Maureen can chime in here because she is still more actively doing hearings than I am. I don't do hearings anymore. And it's the same parties, it's the same residential premises. So I'm guessing that if they wanted to sign a new lease in those circumstances, if that's a tough one, and I'm thinking that something like that may end up in front of a hearing officer, because a tenant may say, well, you know, I just got married and I want my husband on the lease with me. And a landlord may say, well, you know, if you're going to do that, I'm going to have to raise the rent, right? So does it mean then that the tenant will have to sign a new lease? So it's all material that can go before a landlord, excuse me, a hearing officer. The tenant may say, okay, well, I'll have him put on as an occupant, you know, as opposed to a tenant who has tenancy rights. This person will just be an occupant. But it's a lot of give and take and negotiation with the landlord in a situation like that. I couldn't say for sure. All I would say is if it can't be negotiated, then either party can apply to the officer to determine whether a new lease can be put in place or not. And that's how I would look at it.
It may
It's
go
really a
back to
hearing
your,
question.
yeah, it may go back to one of your earlier slides, Lianne, which is that the leases have to be compliant with the Act. So if this is, you know, if it's basically an issue of a rental increase that's contravenes the Act at this time, then it may be something that, notwithstanding any agreement they may have reached, if it goes sideways in any way, shape, or form, it's going to fall back into the Act, and the rent cap, et cetera, is going to come into play. And you know, these are questions that I think Lianne and I anticipated to some extent, and some of them are sort of speculative, and we have to be somewhat mindful of they're sort of one-dimensional questions to a potentially three-dimensional situations. And as you can appreciate in a hearing, we're listening to all kinds of facets to that, what appears to maybe on the surface be one thing going on. And then as you peel back the layers of the onion, listen to testimony and see evidence, other things may come into play. So I think we would just have to be kind of cautious in terms of, we certainly see and hear a lot of people say, well, I asked residential tenancies and they told me blah, blah, blah is how this works. And yeah, again, that's a one-dimensional view of the scenario or the snapshot that was given to the person who was asked the question. And it's often much more complex for anybody who's been in a hearing. You'll appreciate that we have to you know, look at the situation from a number of aspects. But it could be, you know, I wouldn't want to point the finger at anybody, but it could be a way of you know, getting a rental increase is by saying, well, we'll bring somebody else into the unit and now we can charge more, you know, those kinds of things. So again, just wanting to be cautious in terms of what the exact circumstances would be, and bearing in mind that if it did come before an officer, then they'd have to be looking in the Act and to find support for whichever side seemed to feel that they were sort of wronged in the situation.
That's yeah, that's a great answer. I mean, as you know, as landlords, we've all been in that position where people will you know, show up and, you know, be living there. What is the best bet for somebody to, you know, the best route for somebody to take in that situation? So you find out somebody's living there, and then you go and set up a hearing to find out if you can increase the rent because of that specific circumstance. Because I can kind of see both sides. I see, well, you're breaking the terms of the rent cap, but they're also breaking the terms of the original lease. So there's two kind of, you're right, there's more
Exactly.
layers to that than, so would you go to a hearing then and say, okay, well, I'll get back to you, or we'll set up a
Well,
hearing to find out?
I think the big thing is the hearing comes into play when there's a dispute, right? Like if, you know, that you and the tenant are not in agreement with the way this is going, you know, you've got another body in there, and where you might say, you know, I'm not opposed to this extra person being in there, but I want more rent. And so there may be a conversation around that. Then they turn around and accuse you of circumventing the rent cap. And so that person is still not willing to leave, and they're, you know, letting you know that they feel you're circumventing. Then you're in a dispute, right? So then you say, okay, well, we'll take this forward and we'll get a residential tenancy officer to have a look at the totality of the situation and see what are our options, I guess is basically.
And one of the things about an application to director is that it doesn't have to be an allegation of a breach of the lease or a contravention of the act or monies owing or anything like that. You can file an application according to the legislation to determine a question arising under the act. And that's exactly what Maureen is referring to. It's a situation where I'd like to know if I can do this. You know, this is the situation, this is the context. Am I allowed to charge a higher rent in those circumstances? So that's one option that's open to either of the parties to take it before a hearing officer.
I think
challenging ones are always where someone's already made up their mind that they're right before they bring it forward. So, you know, if you bring it forward with the openness, and Jenna referred to this earlier, that, you know, when you look at the outcome and you can see, well, I can see now where where that finding got made, because it's the reasons have been set out. So yeah, but if you come and say, you know what, we're at a loss. I can think of a typical one where I've seen where accidentally the type of lease was two different things were ticked off. So, you know, year to year and fixed term are both ticked. They've all signed it, and now they're in an issue. And so they come forward, and both parties are saying, whatever you decide, we just need somebody to, you know, basically weigh in on this and give us the reasons why it should be one way or the other. And each party has their reasons why they would like a finding in their favor. And then that's where the officer comes in to have an objective look at it and look at the act, the lease, etc., the evidence, and make a finding.
Yeah, that's great. I mean, my fear as a landlord would be to, you know, have the person agree because somebody else is living there, and there's more tax on the house, and there's more, you know, more maintenance and blah, blah, blah. And then they're having a beer with a friend 6 months down the road saying, oh, that goes against the rent cap. And then they go and say, well, you are not allowed to do that, even though I've agreed to it. So I think it's important, like you mentioned, Lianne, is to get that question answered before going and making the change that could come back to bite you, and then you've got a clawback of so many months, which, you know, we've had that happen with a lot of our members. Great.
Okay, that's great.
So Jenna wrote a really great comment here that I think a lot of us would probably be interested in. So is there any kind of advisory board for landlords to join so that they can offer some suggestions for changes that they would like to see made to the Nova Scotia Residential Tenancies Act?
I don't know if any of your members as landlords are members of IPONS. IPONS is one of our stakeholders. We have stakeholder meetings twice a year. We have IPONS, we have Dalhousie Legal Aid, we have Nova Scotia Legal Aid, we have Renters Ed, we have a couple other landlord groups and tenant groups, and we take from them suggestions that they think would make a good addition to the act. Now, we can take suggestions, but Of course, it's not up to us what happens with the legislation. That's the government's decision as to how that goes. But it's always good to know what's out there and what parties think. For example, one of the amendments that has just been put into Bill 30, the one with the counterclaim and the notice to quit, where a tenant disputes a notice to quit and is unsuccessful at the hearing, but there is no counterclaim in place on behalf of the landlord seeking possession of the premises. That is a suggestion that came up, if I recall, back in 2018, it was being discussed, because there are some landlords who are smaller landlords who, there's no license required to be a landlord. You go, there's a house for sale, you decide, okay, I'm going to buy this and I'm going to live in one side, rent the other side out. And you don't need to actually do anything or be able to do anything to rent it out. So you rent it out, but you don't always know the ins and outs and the little nuances of the legislation, so that it's a good organization to belong to, where you can learn these things, get your ideas, So we speak with a lot of the stakeholders, as I say, twice a year. This year we did it virtually, and a lot of ideas come up. And that was one of the ideas. So that's one area that you can do it, because I think the president of that organization, or the chair, is Kevin Russell. And Kevin is a big advocate. We certainly hear him, and he certainly makes his voice heard. The suggestions that come up. There are always the counter-prevailing suggestions as well from the other side of the coin, from the tenant advocates, the legal aids and the ACORN. ACORN has always also voiced their opinions and what should be done with the legislation and stuff like that, what they think is disadvantageous. Yes.
You were talking about IPONs. Can you just tell everybody what that stands for?
Investment Property Owners of Nova Scotia.
So is that something that this group is familiar with, that such a thing exists?
Probably, I'm sure they would be. Yeah.
Yeah, a lot of us are members.
Okay.
Oh, there you go. So I'm speaking to the choir.
Sure that wasn't lost on folks.
No, but there's a lot of new members, so yeah, thanks.
And as Lianne mentioned, the other end of things are the legal aid and the DAL legal aid and things like that, who are often in the advocacy position for tenants. So it's sort of there's both groups have an opportunity to come to the table and bring information and their thoughts and things like that to the residential tenancy program. So
and they're more so at the at our last in-person stakeholders meeting. It was a very interesting meeting. It was very well attended. They were passionate pleas on both sides, some more passionate than others.
Just in terms of this group, Greg and Amanda, I personally can't emphasize enough how important it is for people to also get some legal advice when push comes to shove. I'm a big proponent of this is a legal contract that's in place, and I know that it's often sort of lay people on both sides. In the case of investors and some of you folks that are have multiple properties, you're a little bit more obviously more professional, and as real estate agents and things like that, you deal with legal contracts all the time in your work. But there's a lot of lay people that are entering into these contracts, and they are legal contracts at the end of the day. And I think Jenna mentioned a little bit too about people sometimes come with a lot of emotion and things like that to our hearings and but at the end of the day, we have to look at things very much through a legal lens. This is what the law says. This is what your lease says. This is what you entered into as an agreement. You've entered into a personal relationship, maybe on some level, with the landlord, and that's gone south. And so you're here, but at the end of the day, we are going to be looking at, now that you've brought us in, it's going to be, you know, really very much through a legal lens. So I'm a big, you know, lots of people who approach me, lots of my litigants that I'm going to be hearing will approach looking for information, and I'm pretty much sign off every single email with, and you may want to seek out some legal advice, just simply because to me, that's the lawyer is the person who's going to be really truly in your corner and really truly analyze your situation against the legislation and give you the best advice. So this group may want to get a lawyer to speak who specifically deals with residential tenancies. And there are quite a few lawyers, I believe, in the Halifax area that do a fair amount of practice in that area. So that might be a good speaker to have, because we're standing in the middle of the road, and they're gonna come onto your side in a conversation.
That's great. You've given us some ideas for our next guest that we can have on. Thanks, Maureen.
Yeah, that's a really good point. It is 8:37. This has, you know, we've been together for quite a while, and I believe I hit on most of the questions, if not all of them. So I don't know if you have any last questions you want to jump in there with, Greg, or?
No, I just want to thank you guys again, from you know, Amanda, Rebecca, Jenna, and myself at HREI. Thrilled to have you guys. You've been very open and professional, and I mean, a lot of people think that you know, the tenancy is a big bad beast, but in fact, you know, you're just trying to find a resolution to a problem in a lot of cases. So, you know, you guys are doing a great job, and we appreciate what you do in helping us navigate this crazy world. And thanks again. If you guys want to learn anything else, I think Maureen had put up a few websites there on the chat. So if you want to learn a little bit more online, there's tons of resources. I'll echo what they said about iPlans and Dalhousie Legal Aid. If you Google questions on residential tenancies, you'll get both of those come up in your search results. So those are two trusted sources that you can lean on. And also the members here. Remember that, you know, we have 700 plus members in this HREI group now. And chances are somebody in that 700 has dealt with what you're dealing with right now. So don't be afraid to lean in, but also seek legal advice. You know, at the end of the day, we won't take word, but, you know, learning from each other's experiences is the best way that we can get through this together. If you guys haven't signed up any new members for our newsletter, it did go out today. You can go onto our Facebook page or MeetUp and put your information there. We'll be getting back to another presentation probably in a month or so from now. Keep an eye out for the announcement. Thanks again for everybody for coming tonight. It's always a pleasure, and we'll see you guys again next time.
Thanks for having